Thank you, Mr. Chairman. I want to thank all of our panelists for their very careful attention to detail in this. Professor Rao, I'd like to talk to you about some of your testimony and some of the constitutional implications that we have here. Would it be fair to say that when the Supreme Court articulates a constitutional principle, it's not always articulating the extent to which it's willing to enforce that principle? Would that be accurate?
Yes, I think that's correct.
So you refer to this in connection with the non-delegation doctrine. The Court's been pretty consistent in how it has articulated the principle of non-delegation. And much of this goes all the way back to Charles de Montesquieu, who influenced the Founding Fathers and who understood that there is a difference between the power to make law and the act of delegating to someone else the power to make a law. And so this principle exists in the non-delegation principle itself, as articulated in a number of Supreme Court opinions, even though it's not necessarily enforced in those opinions. But I think there's an important point that I believe you make reference to in page 7 of your written testimony in the text accompanying footnote 33, wherein you make the argument that there's also support for this in the presentment clause. Do you think this represents what could be an independent basis upon which some of this authority could be challenged?
Under the presentment clause?
Yes.
Because delegations allow the agencies to make law without presentment.
Yes.
Right. Well, right. It's without either bicameralism or presentment, right? So agencies, one of the problems with the way agencies exercise power is if they're actually setting the rule of conduct and if they're making the significant and important questions that the legislature should be making, then they're essentially exercising a kind of legislative function. And as you say, they're doing so outside of the requirements of bicameralism and presentment.
Right. And so in the case of Chadha, you had a legislative veto that was being challenged, both on the grounds that there was a lack of bicameralism and because there was a departure from the principle of presentment. The Supreme Court concluded that regardless of the bicameralism problem, it was enough to say that there was an absence of presentment. You didn't have bicameral action by Congress, followed by presentment and signature or acquiescence by the President. That was enough for the Court to say, okay, the final bell here, the final action being taken is Congress, and it's not acting in the manner prescribed by Article 1, Section 7. So that's a problem. It seems to me that there is a corollary to that that says that when the final legislative act, as you might say, is undertaken by an executive branch agency, they're issuing a new rule carrying implications, a new rule of general applicability, imposing legally binding restrictions on members of the public. Could that not also be characterized as a legislative act undertaken in the absence of bicameralism and presentment as prescribed by Article 1, Section 7?
I think in some instances it certainly could be characterized that way. Of course, the difficulty is that the executive branch does have the authority to fill in the gaps, right? So where where they are implementing the laws, there are certainly certain rules and regulations that the executive branch can properly enact.
Sure.
And the difficulty is separating those legitimate rulemaking functions that are part of the executive power from the power that is vested exclusively with Congress, right? The lawmaking power. And it's a tough line to draw, which is one of the reasons why courts, as you say, have not wanted to draw that line very often.
Correct. And so it's not always possible, perhaps, to state with mathematical precision in a single mathematical formula exactly where that line is crossed. And yet you can know when it has been crossed in many instances. I would imagine, for example, you would agree that we would probably have, in addition to perhaps a non-delegation problem, you might well have a presentment problem. If Congress went to such a degree of abstraction as to say, we shall have good law. This is in an act of Congress. And we hereby delegate to the herewith created U.S. Commission on the Creation of Good Laws the power to create good law, the power to promulgate rules carrying the force of generally applicable law that are good. And they'll also have the authority to implement those laws. Wouldn't that create a presentment clause problem?
Yes, that would seem to, even for the undercurrent Supreme doctrine, and violate the non-delegation doctrine.
At the time Chadha was decided in the mid-1980s, the practice of using legislative veto provisions not just of adopting a legislative veto provision, but also of allowing Congress to exercise either a bicameral or, in some cases, a unicameral legislative veto had become rampant for more than 50 years, had it not?
Yes.
And in fact, we had not just dozens, not just scores, but literally hundreds of legislative veto provisions on the books. Few doubted the lack of constitutionality in these provisions. No court had ever held that this violated the Constitution. And yet, was it any less violative of the Constitution?
No.
It was not. I see my time has expired. Thank you, Professor. Thank you, Mr. Chairman.
Thank you.
We have statements